Hello, I'm Corinne Lewis. I'm the moderator for today's panel, and I'd like to welcome you to the 2023 Rule of Law Webathon week organized by the American Bar Association International Law Section, the International Association of Young Lawyers, their Human Rights Committee, and in the International American Bars, Inter-American Bar Association, as well as the UIA IRL, the Institute for the Rule of Law of the International Association of Lawyers. Excuse me. This panel is presented by the American Bar Association, and it will discuss the Universal Declaration of Human Rights and its connection to business and human rights. We are one of 9 different panels being offered during this 2023 Webathon week, dedicated to explore, analyze, and present perspectives on this year's theme: upholding the rule of law in challenging times. The rule of law is society's legal underpinning, guaranteeing human rights and creating economic opportunity and development. And we lawyers are often the first line of defense. The rule of law is not merely the stock and trade of lawyers, it is our core value. The universal commitment of the world's lawyers to the rule of law inspired us to join forces and launch this 3rd event. We are proud to be a part of it. Then I'd like to turn to today's panel. This panel commemorates the 75th anniversary of the Universal Declaration of Human Rights. The Declaration is celebrated as the first legal document protecting universal human rights and underpins international human rights law, international humanitarian law, international criminal law, international refugee law, and many other areas of international law. While the Declaration and the many international law treaties are oriented towards states' obligations, human rights law standards based on the Declaration have now entered the private sphere. Thus, we see soft law requirements, such as the UN Guiding Principles on Business and Human Rights and the OECD guidelines for multinational enterprises, being really transformed from into hard law, regulatory, and legislative obligations for businesses. And alongside these, the ESG, environmental, social, and governance, and sustainability aspects and developments are really fostering profound changes in the risks to and responsibilities of businesses. So the panel of experts today will explain this evolving area and explore the implications for lawyers. We have 5 expert panelists joining us today, and I'd like to welcome them and introduce them briefly. I'll be posting their bios in the chat to allow us to, they're very distinguished, they have very long bios, and to save time and allow most of the time for discussion, you will find their bios in the chat. So the session will be 90 minutes long, and we've reserved approximately 15 to 20 minutes at the end for questions that you can pose in the Q&A function on your screen. So let me now introduce our speakers. First, we have Professor Beth Stevens. She's Distinguished Professor of Law at Rutgers Law School. We have Austin Pierce, who is a Senior Associate at Latham and Watkins in Houston, Texas. David Sullivan, who is the U.S. National Contact Point for the OECD Guidelines for Multinational Enterprises on Responsible Business Conduct, and also Senior Advisor on Corporate Social Responsibility in the Bureau of Economic and Business Affairs in the U.S. Department of State. We also have today Douglas Cassel, who is co-chair of the Business and Human Rights Lawyers Association, as well as being counsel at King and Spalding. And then also Susan Maslow, who is chair of the Corporate Social Responsibility Law Committee in the Business Law section of the ABA. So we would like to start today by having each of our panelists give sort of a brief overview of some points, general points they'd like to make relative to their areas. And then we're going to do a sort of round robin to have them address some common issues before we then open it up for questions and answers. So we will start with Professor Stevens, who will address the relationship between Universal Declaration of Human Rights and business and human rights, and looking at some of the strengths and weaknesses of the Universal Declaration as a foundation for human rights, particularly as it's applied to businesses. So please welcome Professor Stevens. Thank you.
Well, hello, everyone, and thank you very much to the organizers for giving me this opportunity, and to all of you for participating, for listening to our presentations. The Universal Declaration really is foundational to human rights law today, including business and human rights, but it has a somewhat conflicted history. Development of human rights standards was one of the first tasks of the United Nations after it was founded in 1945. And the international human rights framework that exists today, over 70, almost 80 years later, emerged from struggles that date back to those founding early years. One of the struggles was over whether to develop a binding treaty to govern human rights, or a non-binding declaration. A treaty, of course, would have had to be submitted to governments, to states, for ratification. A non-binding declaration just had to be approved by the General Assembly. And the role of the United States in these debates was quite consistent and quite clear. The United States pushed hard and pushed successfully to start with a non-binding declaration, with an agreement that they would then go on to negotiate treaties, which could be submitted to states and become binding. The declaration that came out of that process really is a remarkable document, and I think even more so looking back today. It protects against freedom of conscience, discrimination based on race, sex, religion, and opinion. It prohibits slavery and torture, among many other protections. Those are what we call in the United States the civil and political rights, and internationally they're known as civil and political rights. But in addition to those, the Universal Declaration also protects a remarkable set of economic and social rights, including the right to work, to just remuneration, to unionize, to reasonable working hours and paid holidays, to a standard of living that's adequate for health and well-being, to health care, social security, to protection against unemployment, disability, and old age. So by means of putting this into a non-binding declaration, certainly states were able to agree, and the United States was able to vote for a document that addressed human rights very broadly. So after that, they did set about negotiating binding treaties, but the second controversy was over whether to have one treaty or two. The United States once again pushed very hard and successfully again, this time to divide the rights covered by the treaties in two, so that one treaty governed civil and political rights and another governed economic and social rights. And that's what we have today. And significantly, the obligations in the two treaties were phrased differently. Civil and political rights are immediately binding on states that ratified the treaty, while economic and social rights have more ambiguous language, that they're to be realized progressively to the extent permitted by available resources. So there's a characterization of economic and social rights there as more aspirational and less of an obligation on governments. Going back to the Universal Declaration, which, as I said, was explicitly talked about as a non-binding declaration, many people today consider that it has evolved into binding norms of customary international law, that at least some of its provisions are now binding under one or more various theories, that it gives content to the very general statements about human rights in the UN Charter, which is a binding treaty and talks about promoting universal respect for human rights, and that members pledge to work with the organization to achieve human rights. That language, which I often dissect with my law students in Introduction to International Law, contains a lot of what I call wishy-washy language, pledge to take action for to achieve the purposes of. So there is debate about whether those articles actually bind member states to anything more than a general working together. Another theory is that the Universal Declaration has developed over time into customary international law. And I think it's generally accepted that much of what's in the Universal Declaration is now binding as customary international law. Many states have specifically incorporated into their domestic law, used it as models for domestic law provisions. But the more controversial part remains the economic and social rights, and it's the civil and political rights which are more often considered to have evolved into binding norms. The United States position today remains hostile to recognition of binding norms to protect economic rights, just as it was in the debates leading up to the Universal Declaration and the two covenants. The United States has refused to ratify the International Covenant on Economic, Social, and Cultural Rights, and has no intention of, presidents have said repeatedly, of no intention of seeking ratification of it. So I bring up this history today as we focus on business and human rights on the 75th anniversary of the Universal Declaration of Human Rights to draw attention to the uphill battle we face as we attempt to protect the economic rights of workers and to recognize that businesses have binding human rights obligations. The same forces that successfully resisted a strong binding international treaty on economic and social rights are actively resisting a treaty on business and human rights, which is being negotiated and has been for the past several years. So the resistance to binding obligations, for example, to protect workers in supply chains, demands for a living wage, meaningful access to remedies for those harmed by business operations, that resistance remains strong. And I'll say directly that I'm pessimistic personally, speaking totally from a personal perspective, I'm pessimistic about the ability of the international community to overcome business opposition to regulation and to impose effective standards on businesses. But that's not to say that it's not worth the effort. I consider my personal, my pessimism to be a personal inheritance to my parents, who were longtime trade union activists. They were cynical, and they had no illusions about their ability to win the larger battles against corporate wealth, but they never stopped trying. Similarly, I continue to work for corporate accountability, and I applaud the efforts that you'll hear about on this panel. And certainly these efforts over the decades have had tremendous results. I've focused on some of the larger issues in the big picture, but on, and another picture is just to acknowledge how working conditions around the world and social and economic rights have improved dramatically in the 75 years since the Universal Declaration was adopted. So the history and the current perspective is certainly not uniformly bleak. I was not my choice to speak first on this panel and to start with the challenges we face, but I do feel that it's important to realize how difficult the struggle has been, to applaud those who continue to engage in it, but to recognize how difficult is the road ahead. Thank you.
Thank you, Beth. Great, really great introduction, and appreciate your drawing out for us the contrast between the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, Cultural Rights, which links up very closely to many of the issues that are being raised as violations by businesses, and you highlighted certainly labor. So I think that will carry us very nicely through our further discussion, and appreciate you going first as well. So then let me introduce our next speaker, who is Austin Pierce, and he will provide some context to our business and human rights topic by linking it up to the ESG, the environmental, social, and governance area, and also sustainability for us. Go ahead, Austin. Thank you.
Thanks, Corinne. So I probably come at this from a bit more positive angle. So I work in the ESG space full time, And for those who are first being introduced to it, ESG is a trend that encompasses a variety of concepts, but generally reflects the notion that items outside the traditional conception of business, such as inequality, social issues, and the like, can have a significant business impact, and therefore are important to how businesses produce returns and manage risks associated with their operations. So these risks can come from a variety of angles. There's reputational risks, changes in market expectations, as well as legal action from either government or non-governmental actors. Human rights is a core component of the S of ESG, the social, and as such, of the evolving expectations and impacts on businesses. Two of the ways, related to those angles that I mentioned just a moment ago, from a reputational or market side of things, human rights incidents can impact how businesses are perceived, both by their customers as well as business partners. And from the legal angle, we're increasingly seeing a range of legal frameworks around human rights matters, particularly in relation to businesses. Whereas, as was mentioned, there's been a historical perspective of seeing this as an obligation of governments, this has evolved to subsequently reflect an obligation of businesses as well, though in a different form to reflect the different situations of corporate versus sovereign. These laws can come in a variety of forms. As Corinne already mentioned in the introduction, we have the likes of the UN Guiding Principles on Business and Human Rights, the OECD Guidelines for Multinational Enterprises, as well as for businesses, the UDHR and various UN resolutions. We also have hard law emerging in this space. We have, existing forced labor prohibitions. We have the likes of the Uyghur Forced Labor Prevention Act, as well as actions related to the supply chain, such as the California Transparency in Supply Chains Act, Germany's Lieferkettengesetz, as well as the pending EU Corporate Sustainability Due Diligence Directive. And one of the important trends that I kind of wanted to point out is how there has been an evolution from soft law to hard law in this space. And this is a trend throughout really a lot of different aspects of the ESG movement. But one of the things that I wanted to flag here is how the concept of human rights due diligence is something that kind of percolated in civil society, made its way into the UN Guiding Principles on Business and Human Rights, and is now also being seen in various of these due diligence expectations, whereby companies are expected to take on an affirmative role in understanding the environmental and social aspects of their supply and value chains. This is happening, as I mentioned, in a variety of ways across ESG topics. Just as an example from the E side of things, we have various climate disclosure regulations and obligations coming into force. And these have also similarly used developments from civil society frameworks, such as the Task Force for Climate-Related Financial Disclosures, as a reference point to then subsequently inform hard law obligations that businesses have to comply with. We've also been seeing an increasing willingness of courts to find potential obligations for companies under such international frameworks, particularly when matters are brought using a human rights lens. I'm just going to flag quickly one case here. So in Canada, there was Nevson Resources, which is a case in which it was found that customary international law could form basis for potential liability of Canadian companies, even if breach occurred in another country and, with a happening kind of further out in the supply chain. There was a similar case that's been brought in the United States that was dismissed, but appeal is still pending. And so the outcome in the United States is still a subject for potential development. However, an important part of the ESG movement is not just the talking of E issues, S issues, and G issues in silos. Human rights not just in a vacuum in the ESG space. ESG is intersectional. And one of the key areas of intersection here has been between environmental and human rights matters, particularly then as it relates to businesses. So environmental law has always had some human component to it. It mediates people's relationship with the environment. And many of the seminal laws of the field are rooted in concerns of human health and safety. When we look at how to couch the relationship between environment and human rights, we can generally put it into three buckets. We have traditional environmental issues with human rights implications. So this kind of ties to that traditional notion of environmental law. You can have air pollution that has impacts on health. You can have the loss of species or ecosystems that can impact local communities' livelihoods or the ability to engage in some of the recreational or existential benefits that we get from nature. There's the inverse relationship, where you have traditional human rights issues with environmental implications. This has historically been referred to as the greening of human rights, and it's kind of going from the other side, where we're using well-established human rights as the basis for pursuing further environmental protection. There's also recently been a push for a more synthetic understanding of the relationship of these two spaces. There's been an increasing number of jurisdictions that have recognized a direct right to a healthy environment, as well as the UN resolution on such a right in 2022. Climate change has been a key catalyst for understanding this intersection. When we have the UN Framework Convention on Climate Change, human rights didn't show up as a significant point. But over the ensuing years, various countries, particularly small island developing states, started pushing for a rights-based approach to reflect their needs and imbue the climate discussion with a clearer human element. This resulted in the 2007 Malay Declaration on the Human Dimension of Global Climate Change, which was designed to produce a strategy and coalition to use human rights as a framework for discussing and addressing climate issues. And this has really had a snowball effect over the last 15 years now. And it's been quite successful with increasing references to a human rights angle in the discussion of climate change. And it's also been one of the most successful angles for climate-related litigation to date. This has also been something that has grown beyond climate to serve as a lens for other environmental topics. So rights to water, the biodiversity and natural capital space, which is basically the broader expanse of nature as a collected body, the integrity of ecosystems, the services that ecosystems provide, the management of resources, both natural and cultural. For example, one of the things that I'd flag here is the recently established Global Biodiversity Framework, which has multiple references to human rights as well as indigenous rights and certain qualified references to a concept of rights of nature. And this is likely going to continue as we see more avenues by which human rights factor into business considerations. Each of these topics that I've gone through briefly is an area by which we have seen environmental or human rights topics come to be an increasingly important topic for companies as they are considering their own strategies. From a disclosure perspective, from understanding the relationships with various stakeholders, and understanding their own relationship with some of the entities. For example, in the environmental space, climate change has been the kind of thing that has had clear strategic impacts on decision-making. And in the human rights space, similarly, there have been concerns around, well, okay, if we're not pursuing at least a certain degree of human rights protection in how we go about business activities, or particularly in the financial sector, financing of activities, this can then have knock-on impacts, not just in potential litigation that's brought, but in how to structure these activities. If there is sufficient social license to support ongoing business endeavors. The concept of social license has become increasingly important for the likes of companies permitting of various activities, particularly in extractive or land use sectors. So this is an area where human rights, ESG as a whole, has become increasingly important in the business space. And its relationship with human rights is one where the human rights lens has come on and not only had its impact in the single silo of S topics, but has an important reflection on how companies, regulators, and other stakeholders consider companies' behavior in environmental, social, and governance topics overall. And with that, Corinne, I will pass it back to you and happy to address further questions on this in the Q&A.
Great. Thank you, Austin. And thanks very much for providing this contextual aspect of linking up the human rights from our Universal Declaration of Human Rights with the UN Guiding Principles and the OECD guidelines to environment, climate change and sustainability. And I think this is a really important aspect that lawyers need to keep in mind as we have a number of pieces of legislation that have been adopted in Europe that require due diligence, not just related to human rights, but also to the environment. And then, of course, the sustainability due diligence directive that the European Commission will be finalizing and issuing later this summer as well, which covers both human rights and environment. So this is a really important linkage, I think, for lawyers to keep in mind. So thank you for that. Now it's my pleasure to introduce and have David Sullivan speak on the U.S. National Contact Point and the OECD guidelines. And David has provided a couple links to the OECD guidelines and the U.S. National Contact Point that I'll be placing in the chat as well for the attendees. David, go ahead. Thank you.
Thank you so much, Corinne, for the introduction and for inviting me to speak, which I'm honored to be able to do to this group. And since this is a legal audience, I'm going to just mention I'm in my current job on a detail from my job more than 20 years as a lawyer for the State Department. So I'm happy to talk to anybody afterward about either my current position or the State Department's Office of the Legal Advisor, which in my view is a great place for lawyers to work. That said, I need to say I'm speaking for myself, and what I say is not necessarily the views of the US government or the State Department. So I think what I'm going to talk about, sorry about that, plays well off of what Beth and Austin have already said, compared to Beth's pessimistic view and Austin's more positive view. I may be a kind of glass half full guy, but we will see what you think of this. I will start just by both Beth and Austin mentioned the OECD guidelines. Here's my show and tell. These are the OECD guidelines for multinational enterprises on responsible business conduct. The OECD, as you may know, is an international organization based on like-mindedness. It's an organization of market-oriented democracies. They coordinate economic policies. So there are 38 member states. They've developed these guidelines, first issued in 1976 and revised 5 times since then. They're a set of recommendations. People use the word already in this session, soft law. I'm not a huge fan of that phrase, but that's often used. They're non-legally binding guidance from governments to multinational companies, and they address responsible business conduct, which is a very broad field. It includes not just human rights, which we're talking about today, but also other areas such as labor, the environment, consumer protection, corruption, tax, and competition. The most recent revision of the 5 revisions was in 2011, and it notably added human rights to the topics covered by the guidelines. So that's the OECD guidelines. Since people have mentioned the UN guiding principles, which are probably a bit better known than the OECD guidelines, I'll quickly compare the two. First, they overlap. They're very similar, if not identical, in their human rights language. The human rights language of the OECD guidelines was adopted in 2011, the same year the UN guiding principles were adopted, and John Ruggie was involved in drafting of both of them. So they work together, they complement each other, they reinforce each other. That's the UN guiding principles and the OECD guidelines. I'll mention 4 significant differences quickly. The UN guiding principles are global, with 193 member states of the UN signed on to them. The OECD guidelines currently have 51 adherent states. They're the 38 OECD members, and then 13 others that have signed up to them, states including Brazil, Egypt, Morocco, and interestingly, these days, Ukraine. The UN guiding principles apply to all companies, while the OECD guidelines are specifically directed to multinational enterprises, so a subset of the companies addressed by the UN guiding principles. The UN guiding principles address only human rights, while the OECD guidelines are broader. As I mentioned, they address this broader set of other issues such as the environment and corruption. And fourth, as the fourth difference, the OECD guidelines have a mechanism for promotion and implementation, which is the network of national contact points. I will also just mention before I get into national contact points, the importance of the UDHR to the OECD guidelines and of course to the UN guiding principles. Both of them reflect the importance of the International Bill of Human Rights, which, as Beth talked about, includes the Universal Declaration and the two covenants, the one on civil and political rights and the other on economic, social, and cultural rights. Those are the sort of core human rights principles and rules that are reflected in both the OECD guidelines and in the UN guiding principles. So to move to national contact points, each of the 51 states that adheres to the OECD guidelines is supposed to set up a national contact point. They have a lot of flexibility on how these national contact points are established. I am the national contact point for the United States. Our structure is one person in the State Department in the Bureau of Economic and Business Affairs with a small staff, at least one of whom I think is in the audience here today. So we work very closely with other US government offices as well, such as in state, Bureau of Democracy, Human Rights and Labor, Legal Advisor's Office, and regional bureaus. Outside of state, we work with other agencies like particularly Department of Labor, Treasury, Commerce, and so on. The functions of national contact points or NCPs. First one is to promote the awareness and encourage implementation of the guidelines. So that's what I'm doing now. Thank you for letting me do this part of my job. Second is facilitate the practical implications, something called the proactive agenda. And then third, which I'm going to get into more, there's a mediation process called the specific instance process when a party raises allegations against the operations of a multinational enterprises, and it focuses on finding a mediation resolution through mediated dialogue. So you can raise a complaint or a specific instance to the US national contact point regarding the conduct of a US company or a company in the United States. I, the national contact point, will determine whether to offer mediation to the parties. The process is voluntary, non-binding, and consensual, but it can lead to mediated resolution of the complaint. And we issue a final statement at the end of the process in each case about the complaint and what happened. This is posted on our website. There have been about 50 cases submitted since 2000 to the US national contact points, so about 2.5 per year on average, but the level has not been even. And I'm happy to talk about those later, but I'll turn things back over to Corinne for now. Thank you.
Thank you, David. Great. And my apologies to everyone. We're having a little bit of difficulty pasting David's bio into the chat. So David, I think we'll provide the link that you provided. Ah, there we go. Very good. That's now posted. Thank you, David, for delving a bit into the OECD guidelines and explaining the role of the US national contact point, as well as the role of contact points in general, which I think it serves as a really important mechanism for addressing human rights violations, and particularly for those interested in the issue of remedies as well. So with that, I will now turn to our next speaker, Douglas Cassel, who will speak about business and human rights in the context of sort of the hardening of the soft law norms, picking up a bit on some of the comments that Austin made with respect to developments in the field, sort of concretizing into hard law norms. So Doug, I'll turn it over to you. Thank you.
Thank you very much, Corinne and the ABA for organizing this. It's an honor to be on a panel with old friends and distinguished experts. First, my disclaimer, I'm not speaking on behalf of King and Spalding or any of its clients, nor am I speaking on behalf of the Business and Human Rights Lawyers Association. I'm just expressing my personal views. Before we get into the law, I think it's important that we as lawyers recognize the broader context in which these legal developments are taking place. There's an increasing awareness in society, in the media, in government, and in non-legal circles, and including among businesses themselves, of the responsibility of businesses to respect human rights. You can see that in the increasing focus on business and human rights on the part of leading human rights organizations like Amnesty International, Human Rights Watch, and many others. In the financial community that provides debt capital for companies, in the investment community that provides equity capital for companies, in the rating agencies that rate the quality of investments in different companies and the quality of ESG performance by many companies, in regulations from stock exchanges for disclosures, in new accounting protocols. Even major project insurers are insisting on human rights and ESG criteria in some instances, in the investments by sovereign debt funds. And finally, I must say, among large businesses themselves. Only a couple of years ago, the Business Roundtable, consisting of 200 of the largest US multinational companies with only a couple of dissenters or abstentions, adopted a stakeholder approach to the responsibility of business. Business is responsible not only to maximize profits for shareholders, but is also responsible to its employees, its customers, its business partners, and most importantly, for present purposes, the communities affected by business activities. If you had asked CEOs 30 years ago, do you guys have, or the few women at that time, a responsibility to respect human rights? The answer would have been overwhelmingly no. That's a responsibility of government. Government takes care of human rights. We take care of business. That has dramatically changed. If you ask the CEOs of the Fortune 500 today, do you have a responsibility to respect human rights? Only a few would deny it, and most would affirmatively recognize it. So when we talk about the kinds of legal norms and institutional processes that you've already heard discussed, we need to think of them, we need to understand them as lawyers as taking place in a broader context that affects how rapidly legal change is happening, how seriously the hardening of human rights norms mentioned by Austin is taking place, and significantly, what are the risks and opportunities for major corporations, not only today, but 5 and 10 years down the road, given the current trends, and the trends really in the last 15 years since the UN framework on business and human rights was promulgated in 2008, and especially the UN guiding principles in 2011, which, as David mentioned, have significantly influenced the content of the OECD guidelines as well. How is this hardening taking place? How are these norms that were once soft law becoming hard? You've heard some of it already. One major area is increasingly mandatory human rights due diligence. That has for major corporations. That's already been mandated by across the board in human rights situations in France, Norway, and Germany, not only for their companies, but for supply chains affected by their companies, which means lots of other companies around the world, including US companies, and also for major investors in those countries, foreign companies that invest in those countries. Now the EU is in the process of developing an EU-wide directive on mandatory human rights due diligence and environmental due diligence in the same directive, which it's not guaranteed, but most observers think it's likely that by either the fall of this year or by the spring of next year, the EU will agree on a directive that imposes due diligence obligations and remedial obligations, not only on EU companies, thousands of EU companies, but also on thousands of foreign companies that do business to a significant extent in the EU. At the national level, I think it was Austin who mentioned Nevson versus Araya in Canada. There have also been important decisions under common law tort law in the UK by the UK Supreme Court, making clear that UK-based major companies can be held responsible for human rights violations committed by their subsidiaries overseas, and in some cases by their contractors and even indirect contractors overseas. There have been major decisions by courts, both national and regional, interpreting human rights treaties to impose obligations on states to regulate business. The Inter-American Court of Human Rights in 2021 in Mosquito Divers versus Honduras ruled that all states party to the American Convention on Human Rights, which is most of Latin America and some in the Caribbean, have a responsibility, a legally binding responsibility to regulate their companies in a manner consistent with the UN guiding principles on business and human rights. The Dutch District Court of The Hague has ruled similarly in a case against Shell, relying on the general Dutch tort law standard as interpreted in light of the European Convention on Human Rights. There have been increasing criminal prosecutions of corporate executives and of companies in various national jurisdictions for complicity in gross violations of human rights, criminal violations of human rights by governments and non-state actors. There are increasing restrictions on imports. Already in the United States, forced labor imports are banned, not only from China, but from elsewhere. And there's a pending regulation to do something quite similar in the EU. Even international investment law, bilateral investment treaties, model treaties are beginning to include human rights provisions in them. And some international arbitral tribunals are beginning to interpret even the old treaties in a way that allows states to assert greater protections for human rights against the rights of investors. And finally, as Beth mentioned earlier, there is a UN treaty process underway to possibly create a UN treaty on business and human rights. So there are lots of legal balls in motion right now, and where they are likely to be in 5 or 10 years is difficult to predict, except to say in a general sense that the landscape is becoming such that big companies have to pay more and more attention to risks and opportunities in the field of international human rights. And that means, of course, that large law firms have to do the same, corporate law firms that advise these big companies, like my own law firm, King and Spalding. If you had looked at a roster of law firms, large law firms 15 years ago, who had a practice, who advertised that they had a practice in business and human rights, or even in ESG, you would have been hard pressed to find more than a handful. Now, almost every large firm claims to have such a practice, and many of them actually do. I like to think that my firm is one of the firms that actually does have a practice, and I'm a sort of firsthand witness to the fact that I spend a lot of time advising large multinational companies, as does Austin Pierce, on risks and opportunities in this field. And as that trend has developed, last November in Geneva, we at the UN World Conference on Business and Human Rights, we announced the formation of the Business and Human Rights Lawyers Association of 22 global law firms and some regional law firms that advise businesses on issues of human rights. And our purpose as an association is to make sure that lawyers advising companies have some familiarity with the business responsibility to respect human rights. It's been my experience in all the big firms that I'm familiar with that the vast majority of lawyers in those firms could not begin to tell you what is in the OECD guidelines you just heard about from David, or in the UN Guiding Principles on Business and Human Rights. They might not even have a clear idea that business does have a responsibility to respect human rights, or if so, how to include that in their advice to companies when it comes to mergers and acquisitions, antitrust, consumer protection, securities regulation, environmental regulation, and a host of other fields. Since we announced the association in Geneva last November, 15 additional firms have joined, so we now have 37 member firms. And we have just brought on board our executive officer, who is herself a distinguished legal expert in the field of business and human rights, Meg Rogensack. And I expect that we will continue to grow both in the number of participating firms and in our activities this year. We also allow individual lawyers to join, although individuals don't need to do that if their firm is already a member because they participate in the firm's membership. So this is an incipient effort. There's a long way to go before the corporate legal community understands across the board its responsibilities in the field of human rights. But this is part of the overall trend in what I consider to be a positive direction. Maybe I'll just make one more comment on a point that Austin raised, which is the relationship between human rights and the environment. It's notable that the UN General Assembly resolution of last July that recognized for the first time at the UN General Assembly level a human right to a clean, healthy, and sustainable environment was approved overwhelmingly. There were no dissenters, and I think only 8 abstentions, something like that. The United States was one of the affirmative votes. And in the preamble to that resolution, it was noted that already 155 of the 193 UN member states have in their domestic constitutions, laws, regulations, a recognition of a fundamental right to a clean environment. So the nexus between human rights and environment is very strong. And just one more alert for all of you who may be interested in either field is the pending advisory proceeding before the International Court of Justice, brought originally by Vanuatu, but adopted by consensus of the UN General Assembly, which is to say not a single government stood up to oppose it, requesting the International Court of Justice in The Hague to issue an advisory opinion on the obligations of states with regard to combating climate change, and in particular, in regard to the effect of climate change on the rights recognized in the Universal Declaration of Human Rights, among other instruments. Written submissions on that are due to the court October 20th of this year, and reply submissions will be due January 22 of next year. I would expect that probably by the end of 2024, we will have an advisory opinion from the court that will be a landmark in the connection between environment and business and human rights, and will be ever more important for business operating in this field. Thanks very much, Corinne. I apologize if I went on too long.
Oh, you're fine. Thank you very much, Doug, for your insightful comments. And I particularly appreciated your drawing attention to the fact that there are numerous legislative, regulatory, and sort of litigation developments that are occurring around the world, but that the impacts of those are not limited to the specific jurisdictions in which they're occurring, but affect businesses in general throughout the world, whether it's through the reach of the legislation itself or through the impacts that whether it's litigation or legislation regulatory, will have on value chains in both directions. So thank you for pointing that out for us. And now let me turn to our fifth speaker, Susan Maslow, who will speak about the ABA model contract clauses for suppliers, which I presume a number of you from the American Bar Association are probably familiar with. I know I've heard from lawyers that they're actually using them quite actively. So Susan, I would turn it over to you then. Thank you.
Thank you, Corinne, and thank anybody who's using the model contract clauses. I want to start with an April 2023 study indicating that 78% of the most influential companies globally still do not conduct human rights due diligence. I want to focus on this failure as a question of our clients' effective risk management. Discovery of forced labor and other human rights abuses in the value or supply chains equals value chain disruption, reputational damage, and in several countries under new and pending legislation that Doug and Austin both discussed, very real liability and board exposure. David Snyder, chair of the American Bar Association's Business Law Section's working group to draft model contract clauses for supply chains, likes to say that the model contract clauses were born of challenge, frustration, and hope. Frustration that companies put on their websites principles like the Universal Declaration of Human Rights and the UNGPs or OECD guidelines and due diligence guidance, but do not reflect these principles in the company operations and do not appear to be reducing the scope or the severity of widespread human rights abuses. In fact, at least until very recently, many companies seem to deliberately turn away from what you and I would consider red flags of human rights abuses so they could sustain a culture of plausible deniability. Recognizing that merchants around the world use the Uniform Commercial Code or the contracts for the international sale of goods to reflect their contractual understanding, the idea of the Business Law Section initiative was that contract clauses could be a critical tool for identifying and solving some of the human rights issues as part of the contractual governance of the supply chain. The problem was that commercial law does not really address human rights violations. Soccer balls that are black and white and properly stitched and can be kicked and bounced properly do not appear to fall within the definition of defective or non-conforming goods. But what if the contracts between the parties written by the company's lawyers could offer a path for binding contractual implementation of soft law principles by requiring a supply chain free of forced and child labor, just like the other specs requirements with respect to height and weight, raw materials, mobility, etc. The MCC's Volume 1, published in 2018, focused on the UCC and the CISG with traditional reps and warranties from the supplier. We got a lot of great feedback. Much of it was focused on the role that buyer conduct and demand played in the human rights abuses blamed on suppliers, like unrealistic pricing pressures, delivery demands, and change orders without compensation for previously finished goods. John Sherman of Shift convinced the working group to look closer at the UNGPs and the OECD materials to help articulate the scope of corporate responsibility, whether it was buyer or supplier, in the contract. Version 2.0, published in 2021, changed the MCC focus from previous delegation of or assignment of all human rights obligations on the supplier and dropped the representation and warranty structure and its tick box approach. Do you have forced labor in your supply chain? No. Do you have children in your workforce? No. Will you ever have any human rights abuses in your supply chains? Never. Well, the problem with the tick box approach and the reps and warranties is that you get perverse outcomes, like a supplier's understandable silence upon the discovery of a human rights problem, or the buyer's collection of money damages when remedy of the problem and financial recoveries for the victims of the human rights abuse is the appropriate remedy. With shared obligations of human rights due diligence and remediation in version 2.0 of the model contract clauses, you get human rights improvements in the supply chains. So why should we as lawyers encourage our clients to use the MCCs? I can think of many, many reasons. In no particular order, one might be that the goods are being seized at the border with customs and border protection withhold release orders on the rise. The MCCs can help satisfy the Tariff Act requirements. Another might be that customers and investors have a growing interest in ESG factors, and use of the MCCs can assure them that the corporation is at least trying to be vigilant. Another is that the UNGPs and the OECD guidance insistence that all businesses have a shared responsibility to respect human rights and avoid causing or contributing to human rights impacts that are adverse is embedded in version 2.0. Another is that mandatory human rights due diligence in France and Germany and a host of other countries, as we've already mentioned, is here to stay, and it's coming to the EU. The MCCs make human rights due diligence contractually mandatory. Another is that litigation from activist shareholders groups is on the rise, and efforts to address human rights abuses, at least to date, are given the benefit of the business judgment rule. Inaction is no longer a viable, or at least no longer a safe option. The MCCs can help in the avoidance, or at least the defense, of human rights litigation. And my favorite, contract clauses that make human rights policies legally effective and operationally likely are possible because the contract is the law between the parties. So the MCC toolkit consists of 3 items. There's 33 contract clauses and 110 footnotes. They are pan-industry and modular. The intent is to break down the silos between procurement, compliance, and management. Then there's the building blocks for Schedule P, and the P stands for policies. That's where the details with respect to human rights due diligence and or remediation will sit. A company can use its existing supplier code as its Schedule P, but the toolkit includes guidance on how to improve an existing supplier code of conduct if the company is so inclined. And then there's Schedule Q, the responsible buyer code of conduct. There are lots of supplier codes out there, but Schedule Q was and remains novel. It includes the buyer's commitments for responsible purchasing in generating change orders or delivery requirements, and even in its exit provisions. So the MCCs do not promise value chains without human rights abuses. In fact, they acknowledge the reality that there will be such abuses, and that this reality requires that contracts reflect human rights protections as part of the partner selection procurement process, as part of growing performance requirements, and even as part of the exit. Once the contract is signed, how do you measure effectiveness? Well, there are 4 specific MCC reporting obligations that help the parties gather data. The idea is to have an effective risk management lifecycle, from onboarding to monitoring performance to offboarding, and to actually measure effectiveness along the way. The MCCs can be adopted in whole or in part and modified to suit your client's purposes. The working group has faced criticism for allowing this sort of cherry picking of clauses, but this criticism misconceives the project. The MCC's project was not designed as an aspirational mission. Nothing can be accomplished if model contract clauses languish unused like corporate policies in the minutes of board meetings. For most of our clients, the most critical step is the first step, to start taking measures to improve human rights oversight by improving their contracts. We understand that human rights and environmental protections will not be fixed by contract clauses alone. Still, using the MCCs is one very real practical effort that can result in our clients seeing real improvements in the lives of the people that manufacture and distribute their products. And as an exciting coming attractions, the Corporate Social Responsibility Law Committee has embarked on a RIMC project, the drafting of responsible investor model clauses. And if anyone listening would like to review the first, second, third, or fourth draft of such provisions, please let me know. Thank you.
Great, Susan, thank you very much for highlighting the model contract clauses and providing us with some guidance on how they can be used and their content, and also what they are not. So very helpful. Then I just wanted to remind the attendees to please not hesitate to place your questions for the panelists in the Q&A. We'll be starting Q&A in about 10-15 minutes. So if you could send those, then we will be able to raise your questions to the panelists. In the meantime, I wanted to just sort of pose a couple questions to all of the panelists. And I think what we'll do is go in the order of the speakers as occurred today. And so Beth, we'll start with you. But if you could highlight, I know a number of you have touched on both some of the challenges for lawyers and for businesses, and also some of the trends. And what I'd like to ask you to do is, in looking forward toward the future developments, what are the specific challenges you see, particularly with risk in terms of the roles of lawyers advising businesses? And then also, if you want to touch upon the challenges for businesses and or rights holders themselves who are impacted by businesses. So I'll leave it sort of broad like that. I know you could each have a different sort of perspective that you might bring to this question. And Beth, if you don't mind, we'll start with you.
Yeah, I think I'm going to punt and ask to go towards the end, and partly in terms of time. I think the others have more specific responses they're likely to make to that question. Thank you.
So
Sure.
Corinne, then we're going to me next.
Yes.
All righty. Well, just to kind of, start with the higher level approach in terms of future trends, some of the things from the ESG perspective that relate to this, I'm thinking we're going to continue to see a focus on the human element of climate change and other environmental topics. And this is going to be really part of a push towards a more holistic view on sustainability as a whole. We've seen some of this with, for example, the EU taxonomy's incorporation of minimal social safeguards into their framework of, what does it take to be considered sustainable? And this has been built upon by other jurisdictions, particularly in Latin America. We've seen Mexico come and add affirmative social categories for moving forward sustainability from a social lens. And Brazil has established basically it's this kind of scorecard that looks at E and S and G issues kind of holistically in determining whether something counts as sustainable. Relatedly with this, I think we'd see a push not just to recognize, but effectuate a human right to a healthy environment. This does come with some interesting challenges, though. One of the biggest ones that I see moving forward is really we've reached an inflection point where ESG has historically had a perspective of, well, everything's win-win. We're doing better for the business, better for the planet, better for the people. And we're reaching a point where that might be breaking down. If, for example, there is an obligation to mitigate climate change, and that requires critical minerals that go into renewable energy production. But those critical minerals are then located on, for example, indigenous lands. What's the balancing act between those human rights obligations? What are the priorities that go into how organizations and particularly governments are prioritizing those issues, and how to balance the human rights obligations that are in tension? I think we're also going to see, in relationship to that, some regulatory fragmentation. We've already seen the number of frameworks that companies are asked to bring into consideration proliferate substantially over the last decade. That's not necessarily a bad thing, but it is something that needs to be paid attention to as entities are working to address a very wide range of what have traditionally been non-financial issues to them. Within that, though, as we see different regulation, different jurisdictions take different approaches to these issues, particularly for multinationals, that can lead them kind of into a bind of, okay, well, how are we supposed to go through and have a holistic strategy across the entirety of our corporate structure? We also then have some entities, particularly in the United States at the state level, where we've seen regulators kind of pushing back against the ESG movement overall. We've seen what's a coalition of something like 20 plus generally Republican-led states have been trying to pursue various angles to say, we don't want you considering ESG items. There's been a push that for investors doing it to couch it as a breach of fiduciary duty. There have been arguments brought forward that, well, maybe this is an antitrust concern because you have major players in these spaces pursuing topics and saying, and well, that has impacts on market competition. You're raising prices potentially as a result of these additional obligations that you're having to price into your considerations. And well, okay, that might be a good end, but antitrust is kind of in your way there. Whether that is an effective theory or not is a separate question, but these are the kind of things that we're starting to see come out in force and really get articulated with a legal language now and with legal implications. Last thing I'm going to flag is just kind of moving to the role of lawyers. The important way to be able to respond to some of those things, particularly on the I'll just call it anti-ESG for lack of a better term, inform clients of the range of obligations and expectations that are out there and help to translate human rights and frankly all ESG matters into language that is intelligible to the company's business thesis. How does it impact risk? How does it impact return? Of course, there are broader impacts that excuse me, that can result from some of those items. But in order to keep things working within the realm of business, kind of as Susan was mentioning, you got to take the first step. And if part of that is keeping things framed in a way where you can show the supportive business logic to be able to take these actions, that is one of the first steps to do. And the ways this can kind of show up, just some of the ways it's shown up in my own practice is helping to perform due diligence on human rights and indigenous rights matters, developing strategies and policies on these matters, just educating the board and management on the importance of human rights and how it relates to their businesses, both from a hard law and broader stakeholder perspective. And then in translating that into actual business actions, incorporating relevant representations and covenants into business agreements, such as the model contract clauses that Susan was talking about earlier. I will pause there. I could keep going on this forever, but I know we have other interesting insights that people want to give.
Great, thanks, Austin. David?
Thanks very much. Quickly, one kind of emerging issue is that we're doing an update to the OECD guidelines. So what I told you about was the 2011 edition. We've spent more than a year negotiating an update to it, which we expect will be adopted by the OECD next month. So there will be, if everything goes according to plan, a 2023 version of the guidelines. It's going to address some of the current issues people talked about today, particularly climate change and what's the business responsibility regarding climate change. Also, the text section is revamped to reflect recent developments. One challenge that I face regarding the guidelines is that they're not that well known. So they're well known among, I'd say, Fortune 500 companies, among major labor unions like the AFL-CIO, and among the NGOs that really focus on business and human rights. But outside of these communities, they're not that well known. So I'm going to do an ad for myself, which is that I'm happy to do any sort of outreach in the future like this to groups that should know more about the OECD guidelines. You mentioned the perspective. I'm going to mention two different perspectives. The perspective of rights holders. I think, rights holders, there are communities that don't know about the guidelines, that aren't, the AFL-CIO or, the major business and human rights NGOs. And if you work, ad number 2 here, if you work with a community that has a human rights concern and relates to multinational company, this might be a mechanism that could be useful as a way to raise that concern. So I'm happy to talk to people about our process and whether it might be useful in this situation. Then you also mentioned from the business perspective, and I think there we have a concern. There was a peer review of the US National Contact Point about 5 years ago, and one of the findings that we were criticized for, which is pretty strong criticism, is that 2/3 of the US companies that were offered mediation declined that offer, and there was not a mediation held by the US National Contact Point. So I'm trying to reverse that. And I will say, if you're a lawyer for a company and you hear about one of these cases involving your company, please talk to me. I'm happy to talk about what the process is and demystify it. And I hope, persuade you of the potential benefits of engaging in this process. So those are my thoughts about some of the challenges, along with a few ads. So I ask for your forbearance on those. Thanks very much, Corinne.
Thanks for both of those, David. I think that's really helpful, and that you're plugged to have the U.S. National Contact Point better known is very valuable. Doug?
Thank you, Corinne. I'll just go back to a point I made earlier and amplify it a bit, namely the abysmal ignorance among the overwhelming majority of business lawyers, corporate lawyers, about the business responsibility to respect human rights, about the UNGPs, about the OECD guidelines. I would put a number. I haven't done a scientific study, but based on my experience, not only in my own firm, but talking with people who do this work at other firms, upwards of 95% of the lawyers in big firms who should be advising business on all these questions could not tell you what's in the UNGPs, even at a basic level, let alone the OECD guidelines. Until we overcome that, lawyers are not going to be fulfilling their responsibility to advise companies about their responsibility to respect human rights and what those implications are. All of the kinds of issues that Austin raised are wonderful issues if you have a lawyer who is already familiar with this terrain. But most lawyers in business law firms haven't got a clue. And we have a huge educational mission ahead of us to try to overcome that. That's part of the reason why this new association I mentioned has been formed. And it's one of the reasons why this Webathon that you've organized, Corinne, is an important part of the overall educational effort. Thanks.
Thank you. Great. Susan?
So I think one of the biggest challenges for implementation of the model contract clauses or similar initiatives is the past, as I think all of the other panelists would agree. Suppliers historically have not had the leverage that would make negotiations of contract clauses equal and fair. So there's much in the existing structure that works for the buyer, the assignment or delegation of all obligations on the supplier to be sure that there's no human rights abuses in the supply chain. In a sense works because indemnification is a concept that's upheld by law and by contract. The fact that such delegation is completely ineffective to addressing the human rights problem is another whole matter. So I do think that that's a challenge. Other challenges are actually reflected in the footnotes to the model contract clauses, including antitrust concerns that actually Austin mentioned, and theories of anti-competitive behavior in addressing, especially if there is a supplier that is used by multiple buyers, and coordinating efforts to address a human rights problem that's probably exists in the multiple buyers supply chain because of the supplier's single factory or some other factor. The other one would be, I guess, a belief in the shareholder primacy, especially here in the US, and that means profit maximization, because clearly a human rights due diligence obligation that's shared by buyer and supplier, and buyer responsible purchasing practices is going to raise the price. I mean, there's just no doubt about it. I mean, look at whether it's chocolate or coffee or 148, I guess, products that have been identified as potentially involved with human rights abuses. So prices are going to rise, and if you believe that shareholder primacy means the maximization of profit, as I do not, then there's going to be resistance to any kind of effort that's going to lead to higher prices.
Great, thank you, Susan. And Beth, we can come back to you now.
Well, I'll just say very briefly that I remain just totally torn about, obstacles and perspectives. I think I'm totally impressed by all of the work that all of the panelists are doing. I think every project is important, and the direction that we need to go. And I also think that, that all of these projects run into political and economic barriers. Our governments could have set up a world in which corporations had greater responsibilities and clarified that, but they didn't. And we, the people, were not capable of pushing for that. So for the but for the moment, as on so many issues nationally and internationally, we keep working. And to my mind, it doesn't matter whether it's we have a small impact or a large impact. We have to keep working. But I'll leave it at that.
Great. And thank you for your views. And as you were talking, a number of you mentioned the fact that we need to ensure that lawyers are more conversant with the UN guiding principles and OECD guidelines and developments in the business and human rights field. I just wanted to mention two events that are coming up that are being sponsored. One jointly by the American Bar Association with the European Bar Association. That's a training program that's being held in Madrid, Spain, from July 10th through 12th. And it's really intended to be a close-up focus on business and human rights and the various aspects to really bring lawyers up to speed on integrating business and human rights into their practices. And then the other is a conference in Paris from December 6th to the 8th. And this is in commemoration of the 75th anniversary of the Universal Declaration of Human Rights. And like this panel, we'll have a business and human rights focus as well. So we hope you will be able to join us for that. Then, if I may, I just want to turn to some of the questions that have been posed in the chat. I think one attendee has raised a question that I think, Doug, you've addressed a little bit, but maybe you could explore a bit further. And that is for new attorneys, and maybe Austin as well, for new attorneys who are trying to break into the area of human rights or to develop the skill set. Can you make some suggestions in terms of what might be helpful as sort of starting points for making either a shift or starting in this area of business and human rights?
Sure, and that's the easiest question I've ever been asked to field. Start by reading the UNGPs and the commentaries. Then go quickly over to the OECD guidelines, but don't bother to read the old ones since David says we're going to have a brand new model coming out in a month or so. Thirdly, get yourself on the mailing list, the email mailing list of what's called the Business and Human Rights Resource Center, based in London, but with offices in various continents around the world, that tries to keep track of developments in the field of business and human rights, and whether it's court decisions, legislation, draft treaties, model contract clauses, NGO reports, whatever. They send out an email update every week. And by reading that, you can get a pretty good idea of what's going on. And then finally, I would say that for any human rights lawyer, whether you're working in the field of business and human rights, or whether you're working against violations by governments or non-state actors, such as guerrilla groups, respect the people who are affected. respect the rights holders, respect the victims, work with them, consult with them. Don't parachute in from outer space and pretend that you have the answers or the right priorities. Find out what the people who are directly affected think, what their representatives think, what the NGOs who defend them on the ground think, and try to support their needs rather than to impose what you think their needs ought to be.
Austin,
you.
do you have something to add? Yes.
Sure. I think the only thing I would really add to that is also consider if there is an area that is adjacent to human rights that you already have expertise in, where you could find an intersection. Because, you know, for example, from my own experience, I do a lot in the intersection between environmental issues such as climate change or natural capital and human rights. And to be able to speak in both languages, for lack of a better term, is very effective, particularly in some of these more conceptualizations of human rights that we're seeing. I mean, Doug is right. The first thing you've got to do if you want to do the stuff with the human rights is understand the basic idiom and tools used in human rights. But then after that, what are the things that you're trying to affect? Where are you trying to have an impact? If it's just, you know, wherever I can get involved with human rights, that's totally fine. But if there's an area where you're trying to, you know, dive in on deeper, what are the intersection points? Where can you bring a form of expertise that will be additional, be part of the conversation?
Great, thank you. David, I have a question. I think would be directed toward you. And please, others, please feel free to comment afterwards as well. If you could perhaps highlight for us some of the reasons for the differences between the provisions of the UN guiding principles and the OECD guidelines. I know the OECD guidelines in 2011 were influenced by the UN guiding principles, but I'm wondering if you see the changes that are being made now to the OECD guidelines, bringing sort of more in parallel with the UN guiding principles. I mean, even if you look at due diligence, for example, you see that UN guiding principles talks about 4 basic steps, and the OECD guidelines frames them a bit differently, has sort of 5 steps.
Sure, thanks, Corinne. I would first start by sort of re-emphasizing the overlap between them. If you do a Venn diagram, there's a really significant common ground between the OECD guidelines and the UN guiding principles. And I think that's really important to us, that they are, you know, they're identical or very similar in their terms on the key human rights, the key way that, you know, businesses should respect human rights. But in terms of why there are the differences, I mean, one thought is just sort of institutional differences. So the OECD, as I said, is not all the countries of the world. So that is a reason that maybe it's easier to address a broader set of topics that's not just human rights, but the things like corruption and the environment. You have sort of like-minded states that have developed them. And that's also a reason that they were able to develop the national contact point system. There's a like-mindedness among the states that developed the OECD guidelines. So they were able to go a little deeper in those ways. But then the way in which, one way in which the UN guiding principles are broader, the coverage of companies, I think that's a result of the OECD guidelines coming out of something called the OECD Investment Declaration, which is what companies say they should, what countries say, how they should handle foreign investment. So the context is foreign investment, although the OECD guidelines say they really, you know, there's no reason that these principles don't apply to all companies. They're directed specifically at multinational enterprises, that is, ones that are, you know, operating internationally. So those are maybe some reasons for the differences, but again, I would really emphasize the commonalities between the two and their sort of reinforcing nature of each other. Thanks.
Thank you, David. And then I think maybe we have one final question here in the Q&A that I don't know, Beth or others, please feel free to respond to. Noting the issue of, and David, you just mentioned actually corruption, because since corruption in many ways affects human rights, in part from drawing resources off from the state that could have been dedicated to the state's financial fiscal responsibilities, health, education, social assistance. And I'm wondering, so how you might see this issue of corruption linking up with human rights, business and human rights in particular. Somebody, that's you
No.
game? No, okay. Someone else?
I mean, I'm also mindful of the time, but we also, it's a good cop out. We have, I mean, I think that it's clear as the questioner is expressing that corruption undermines the ability to enforce any international norms. And, one of the issues that has been really part of the foundation of efforts for business and human rights has been improving the rule of law. So, why did we sue US-based corporations in the United States for things we say they did in other countries? Well, it's partly the framework of multinational corporations that they've insulated their assets, and US courts can get hold of them. But it's also often because of the rule of law, and which means courts in domestic countries that don't have the strength to rule against corporations that might be corrupt, and the danger to the people involved, which also might involve corruption of the security forces. So I'll see if David and Austin want to add something there.
I'll just jump in very quickly to note a source for a comprehensive thesis on this. The 2019 thematic report on corruption and human rights of the Inter-American Commission on Human Rights talks about it from an inter-American perspective, but what they say applies globally. Anybody interested in the intersection between corruption and human rights, that's a terrific source to begin.
Great. Austin?
Sure. So the one thing I just want to add is, to tie this back to the business and human rights perspective, this is one of the areas where something, businesses already oftentimes will have a hotline for issues to be reported. Hotlines can be a really useful tool for corruption and human rights issues and labor rights issues. And you want to make sure that that hotline is resourced to be able to address all of those, and then to also have the procedures in place to get those issues to appropriate management and oversight, so that businesses can address those issues to the extent they are aware of them and they come up.
Great, thanks. And David?
Yeah, I'm just going to throw out an idea, definitely not speaking for the US government, but there's a really interesting idea that's come out in the area of the overlap between corruption and human rights. Of course, US lawyers are very familiar with the Foreign Corrupt Practices Act from the 1970s that criminalized corruption. And a couple of lawyers, or a couple of professors, Jenna Martin and Rachel Chambers, wrote an article in the last year proposing a Foreign Corrupt Practices Act approach to business and human rights. And I think that's an interesting idea in this area, as opposed to the due diligence approach that Europeans and others are taking, but to really have a kind of a criminal law approach to this, which is an interesting thought. Thanks.
Thank you. And Susan?
Just wanted to add that the process, whether it was an operational level grievance mechanism or hotline, it is exactly the kind of thing that can be put in your Schedule P for policies in the MCCs. So that kind of detail is very difficult to put in a contract unless you're willing to go with the US mode of 400 pages. But a Schedule P is the right place for that kind of thing. And then both supplier and suppliers representatives and all the, as you go down the tier, cascading down, everybody knows exactly what's expected with respect to corruption and who's supposed to be getting the money.
Great, thank you. And I'm conscious of time. We're just a couple minutes over, so I'm just going to quickly wrap this up. And I first want to extend my really heartfelt thanks to our excellent panelists today. And to all of you who've attended and for your very stimulating questions. Thank you for those as well. And I wanted to let you know that the Rule of Webathon doesn't stop here, but will continue. The next program that starts in just about a half an hour is the Global Impact on U.S. Democracy. So that starts at 1 p.m. Eastern Time. And to register for that program, if you could please click on the link that should now be posted in the chat. And again, thank you to all of you panelists and to attendees for a very interesting, stimulating discussion today. Thanks. Take care, everyone.
Thank you.
Thank you.
Thank you.